Greetings, my fellow Americans, and welcome to the Great Montana Conspiracy Podcast. Today we're going to be talking about interlocutory orders. Now, that may sound complicated, but it's not really. All it means, if you break it down, is an interlocking order that's designed to hold the case together while it's pending its process and its procedure, ongoing to a final order and resolution of the case. In theory, this is perfectly legal. But how does it affect you if it's used wrong? Welcome to Montana. Okay. Basically, in a nutshell, they are intended not to be permanent. A restraining order, for instance, to enjoin someone from selling a property, or to get rid of something, or to, if it's a custody issue, an order instructing a parent not to take a child out of the state while the custody is pending, i.e. taking the child out of the jurisdiction of the state. These are what are standard interlocutory orders. They're not designed to be harmful. They're not designed to resolve anything or settle anything. They're basically to hold the case together, to hold the issues in place while they're being disputed, while the court makes its non-adversarial position to make a resolution that's fair and lets all the parties be treated equally under the law. It's not done that way in Montana. In Montana, it's a whipping stick. It's a shield that's used to protect judges and oftentimes preferred elite clientele from consequences. For example, if you remember how I said an injunction is often a preliminary interlocutory order? Well, if you, for instance, sue over title to a property, and you would go to the court and ask for an injunction on the sale of that property. And the problem is, what happens if the court does the opposite? What if the court allows the property to be sold while the action is pending? Then where's the case? Where do you get anything? If the property at issue sells, the damage is done. There's no way to unring the bell. Okay? So what you have here is a situation to where in Montana, judges who simply don't want to deal with issues, where they don't like the parties or they prefer one client over another, if they're dealing with their bigotry towards pro se litigants as an example, and they don't want to deal with a pro se's argument, and they want to give preferential treatment to the attorney who's handling the case, oftentimes what they'll do is they'll issue interlocutory orders or preliminary orders that are designed to cause irreparable harm, and thereby making the entire case moot. As an example, let's use that example of the property. If I, for instance, have a property at 123 North Pole Lane, and I have this property, and I find out someone has tried to sell it. They've tried to represent it as their property, and they successfully, without my knowledge, sell this to somebody else, and somebody comes onto my property and says, hey, I just bought this property. And they've got this deed and everything else because this person has gone down and done whatever he needed to do to fraudulently remove my name, put his own name on, and proceed with the claim. Well, obviously, he can't proceed with the sale legally, but to fix the problem, I might actually have to go to court and sue him to prove he didn't have a rightful claim. Now, in a typical standard procedure, an interlocutory order or preliminary order would be issued to stay that property. That property cannot be developed, it cannot be sold, it cannot be anything else because it's now in question. It's pending a resolution. Oftentimes, you have what are called lis pendens filed on these types of properties and situations and circumstances to prevent properties from being disposed of during the term of a lawsuit. Now, imagine if the other side says, hey, I don't want to be involved with this, I want to sell the property, or I want to tear down the buildings on the property and renovate and do whatever else, but this lawsuit is preventing me from doing so. So I would like an order allowing me to tear down the residences, tear down the property, and continue with my own construction project while this lawsuit is pending. Well, if I'm living on this property, I have my house, they want to tear down my house. They want to tear down whatever I've built. If I have a garden out back, that's gone. If I have any storage units, those are gone. Garage, everything gone, because they want an order that says they bought the property. They consider it, regardless of whether they bought the property fairly or acquired it fairly or legally, they feel that they're losing money from not being able to continue with their excavation and destruction of the property as it exists and building new whatever on the property. If the court comes in and says, okay, we'll grant that motion, we'll let you go ahead and continue the construction while this action is pending, the harm to me is irreparable. I can't get my house back. But under the rules of interlocutory rules, it can't be appealed. Why? Because the case is not final. You go to court to settle the issues and to hold everything in pending action while you're waiting for this to get resolved. But if the court turns around and says, no, we're going to go ahead and grant that motion and allow this construction to proceed so that this business's profits are not impacted, ignoring the right that I have a right to this property and that destroying the property as it exists is irreparable harm, you've got a problem. Under Montana rules, as with most state rules and most systems, it's not appealable because the decision is not final, even if the damage caused is irreparable. And that's a circumstance that exists in a lot of these interlocutory appeals, or necessity of interlocutory appeals. Now, there are some narrow windows to bypass this and get through this. But basically, the problem we have here is that interlocutory orders are used to shut down lawsuits. They are. Plain and simple, they are used to shut down lawsuits, to remove if there's no longer a house, if there's no longer property to proceed, my claim for preserving my property is moot. I might eventually prevail and get the title back to the property, but the damage is done to the property. My ability to live there, my ability to have personal memories, anything I built or constructed on the property is gone. All of it's gone. I've lost everything that has of value. Any investment I made in that property is gone. All because an interlocutory order would have been issued that said it's okay to continue construction. Judges in Montana frequently and routinely issue orders that make proceedings with a claim moot. For instance, as I said, if the case is pending for property, the court issues to sell the property or to allow renovation of the property that would make the pursuit and claim of the property pointless. Let's say this property is on the edge of a lake and they want to dig it out and make a giant bay, a private bay. So they want to renovate it and tear my entire lakefront property out and make a giant bay of water. And there's not even a way I can rebuild a house. So they may go in and get new zoning and I can't build. I mean, any number of circumstances can exist to where the changes allowed to occur will be irreparable. As another example, if it's a case that's pending for custody, if a court grants permission for one parent to take the child out of state before the custody issue is resolved, the child's now outside the state's jurisdiction. No more case. The case is moot. Montana no longer has a claim. If the court says, okay, it's okay for Jim Bob to take his son Sidney to California, forget Margaret. He's going to take the child to Sydney. Sydney's to California, and Sydney doesn't get to have to come back. How? How is Montana going to enforce a child in California to come back? They can't. They're in California now. They're in California's jurisdiction now. So the idea here is that interlocutory orders are not meant to create irreparable harm. And when they're allowed to create irreparable harm, they create a situation of circumstances where cases simply cannot proceed. Once the subject of the suit is gone, the case proceeding is moot. You cannot unring a bell. If the bell has been rung, if the property is gone, if the child is gone, if information is disclosed preliminarily, as an example, you can't unring it. Once the damage is done, once it's irreparable, once it's gone, it's gone. So how do you fix this? When Montana courts routinely hide behind interlocutory rulings, they do so to prevent appeals. Because if the case is dismissed without resolution, there's nothing to appeal from. If my property is gone, if my house is gone, I can appeal their decision, but only if the case is done. If they resolve this, they tear down my house, they build condominiums, they've got They're selling the condominiums to other people. Where's my claim go? Maybe, perhaps someday, resolving down the line, if the case is allowed to proceed, I might get the title back, but the damage is done. It's irreparable. I can't get back what has been lost. So what's the point of appeal? If I lose the case, I can appeal the case and possibly, like I said, eventually get the property back, but the damage is done. The idea is, if I've lost my house, if I've lost my investment, if I've lost everything, what's the point of continuing? And that's really what the Montana courts want people to think, especially the pro se litigants. Because if they don't have a way to fight back, then their claim is pointless. I helped a lady several years ago who literally had someone coming out and putting a 4x4 bolted to her front door to bar her from her own house. And the court allowed it. They allowed it. They allowed these people to come out to dig up her pipes, to tear down trees, to allow construction to continue while she was trying to fight back against their claim on the property. Because they came in and they wanted to buy up the property. They went through, they improperly made a claim against the property, put a lien on the property. They didn't have a rightful lien. They just put the lien on the property. And then they went to court to quiet the title. And while the title was quieting, they got permission from the court to proceed with the construction. She's still living on the property. It's her property. And they're doing everything they can to harass her and bar her from the property. She literally has to get around this 4x4 every time she kneel down this far from the ground to get into her own home, or climb up over this 4x4 to get into her home. The damage done to the door, obviously, it's like these massive bolts she had no way to get rid of. They had to use a huge jackhammer to get these bolts on to begin with. What's she going to do? Do this all day? It's on there permanently. She has no tools to remove it. No harm done to them. And eventually it was a bit of a war of attrition. She finally had to give up her home because they made her home unlivable. They literally went out and tore up her pipes. She couldn't have any plumbing. They took out the mailbox and she couldn't receive mail anymore. They did all these things, couldn't do anything, because the court allowed the construction to continue while the claim was being quieted. They never had a claim to begin with. They were literally forcing her off her property, and the court allowed it. And that's Flathead County, folks. That's right here where I'm at. I saw the case. I watched it. I sat back in frustration as she was trying to deal with it. Days when I wish I was an attorney and I could go into court and represent her, but they wouldn't ever let me have a law degree. Ever. In my own case, I filed my case against Mara, my ex-girlfriend, who took all my business assets when I went to prison, for herself. I filed it in 2007, while I was still in prison. I wasn't released till 2009. The case was originally filed in Dawson County and was shifted to Flathead County, where it has stayed in limbo since 2008. The court clerk wouldn't even issue subpoenas or summons to serve the parties in the case to demonstrate that it was in a new jurisdiction. Could not serve them. When Heidi Albright came under the case, circa 2010 or whenever she came in, she reviewed the cases and she said, okay, what's going on here? I'm going to dismiss this case if I don't have a reason. And I wrote a response back to the court and said, this case is still pending. The court clerk refuses to issue summons. She ordered the summons issued. They were issued. They were served. And guess what? Mara never responded. I filed for default judgment. She didn't file a response. Weeks went by. The proof of service vanished from the court file. 3 copies of it, ladies and gentlemen, vanished from the court file. 3 copies. The copy originally filed by the Sheriff's Department, my own copy I sent in, and a copy I attached to my motion for default judgment. All vanished from the court file. Somehow they were not filed. So after finally Mara files a response like 3 weeks late, the court comes back and says, well, now she's appeared and therefore a default judgment isn't proper. I filed an appeal. Even though it's an interlocutory issue, it was critical the case should have been done. The court was required by mandatory language of the law to grant the default judgment. It's not a in justifiable terms. If you see a law that says a court may or a court should, those are discretionary. If you see the language of they must or they shall, those are mandatory. The court must do what the law says. And in Montana, it says the court must issue a default judgment if the party does not respond within the requisite statutory time. 3 weeks late, and they allowed the case to proceed. And ever since then, the court has refused and ignored every effort I has made to get them to set a trial schedule so this go before a jury. Since 2007, ladies and gentlemen, this case has been pending. In case you may be watching this video at some future date, it is now 2021. This case has been going for 14 years. Not because I'm delaying it, not because I'm doing these requesting for extensions or anything else, because the court will not set a trial schedule. When I appealed on the grounds that the court was clearly in error, it was denied. Big surprise. Montana Supreme Court never grants my motions, never grants my appeals, never grants my writs for supervisory control. They deny everything I put in front of them. Usually it's behind, unpublished opinions, which I've talked about before. But the case is pending and I can't appeal it because it hasn't settled. All these interlocutory orders, even the presumed denied, when I file a motion for setting the trial schedule, when I set a motion for default judgment, when I set a motion for all of this, it's all pending. It's all interlocutory. And therefore I can't appeal it. And so the case stays in limbo indefinitely until the court either decides to close the case and dismiss it, which would give me grounds to appeal, which they obviously and clearly will not do, or they allow this case to go to trial, which they don't want it to go to trial. Because the only thing this case is going to be is jury of 12 people. Here's the Montana Secretary of State records that show that the business was in my name. Mara will be unable to produce any such documents because it was never in her name. All assets of the business are mine. Case closed. It's an open and shut case. It literally is an open and shut case. Heidi Albright does not want this case to be heard because it would give me access to the resources they stole or allowed to be stolen from me when I went to prison. They know Mara took all of this. They're fully informed of it. The information is there in the complaint. The information is there throughout my pleadings. My information is in my book. Information is on my blogs. It's everywhere. The information and the evidence is posted on my blogs. They don't want this case to go before a jury, so they simply hold it in limbo indefinitely and use the interlocutory system to keep it from being appealed. And it's kept it from being appealed for 14 years. How much longer can this thing last? And every time I try to file supervisory control over this court, they ignore me. They shut it down. And I have filed 3 supervisory controls. 3 supervisory controls. 2 of which were denied. 1 was just flat out dismissed and not accepted. So what does that tell you? That tells you the Montana Supreme Court is not going to grant relief no matter what I do. And the U.S. Supreme Court case won't hear my cases, so what do? Where's my remedy? The reasons Montana does this, okay, and it's so much broader than just issues of, protecting the lower courts. It's about power. It's about power and it's about control. Montana is one of 8 states in the Union that do not have intermediary appellate courts. In Montana, 7 people, 7, control the entire judiciary of the state. And in this instance, shelter the judiciary from corruption charges. 90% of the time, when, ladies and gentlemen, meet Wade. He's deciding to cry over here on the side. he wait. Here, hang on a second, everyone. You've met Felicia. This is Wade, and this is the guy who's crying over here on the side. Say hi, Wade. Yeah, this is Wade. Now go on, Wade. I gotta work, buddy. Okay. So now hopefully he's had a chance to be heard. Hopefully he'll be quiet now. At any rate, the reason why Montana does this, and it's very plain and simple, is that they want to keep power and they don't want the corruption element to be exposed. Remember in my previous episodes, I'm sorry, he's a talker and he wants to talk over here. In my previous episodes, I've talked about how everyone in the state want the federal government to stay out of this. They also want to hide these issues from the public. That's why they have the unpublished opinions. That's why they don't want the SEC coming in. That's why they don't want to be reviewed by federal oversight. They don't want a RICO action against the state. That's why they've placed their own people within federal stations within the state to prevent the federal government from coming in and actually investigating and looking at what's wrong here. And this is a circumstance where you have 7 people, led by Mike McGrath, who's the current head justice, and they control all aspects of what happens in Montana. They keep the judiciary's corruption under wraps. And 90% of the time, when it's necessary for an interlocutory ruling to be brought in, it's because the justices have done something wrong. Montana Supreme Courts, they shelter the courts, they shelter the judges from consequences. They routinely uphold even the most perverted rulings if it deals with judicial inappropriate conduct or inappropriate rulings. If it's a subject matter of law and it doesn't raise any questions of impropriety on the part of the judge or the lawyers in the case, there's a chance they might, actually rule in the law. But if it starts challenging the judicial conduct or saying the judges are acting inappropriately, forget it. It's done. It's over. Typically, appeals overturned never rest on judicial misconduct. They rest upon lawful actions or lawful questions of law. I can't find any cases in the last 3 years, and I've been reviewing cases. I reviewed cases for this podcast, in fact, trying to find cases where a case was overturned based upon impropriety by the judge. I can't find any. I just can't find any. Just as an example, just to show you how rare these overturnings are, in 2020, we had 31 supervisory control cases filed. 4 of them were granted. In 2019, we had 33 filed. 1 was granted. In 2018, we had 29 filed. 1 was granted. Give you kind of a pattern here. They're not granted because the courts don't want to acknowledge impropriety. And unfortunately, in those statistics that are provided by the Secretary of State or the court clerk of the Montana Supreme Court, they don't provide which cases are what. It's going to require some extensive research and reading and figure out which cases are what, to figure out which cases are the ones that were granted, what the subject matter of them were, and to find relative issues. And quite frankly, reading 100 cases is something I don't have time to do right now. So forgive this, just the statistics, and the statistics have to stand for themselves. When you have 31 supervisory control claims made in the state of Montana and only 4 are granted, or you have 33 in the previous year and only 1 is granted, you have to wonder what conditions allow for them to be granted. Granting it is incredibly rare. In fact, in 2020, writs of habeas corpus, not a single one was granted. Not a single one. Over 100 writ of supervisory control cases filed, not a single one granted. Because Montana Supreme Court does not grant relief based on law. It grants relief almost universally based on politics. I would lay odds if we went through and took the time to review those cases that we'd find a political angle as to why the relief was granted. But it's certainly not being granted in the circumstances or situations where it needs to be. Now, There are ways around interlocutory rules. I mentioned supervisory control already. Montana Supreme Court actually opened this avenue back in 1989 in a case called State ex rel, which in relation to First Bank System's First District Court. And if you're interested, the actual citation number is 782 Pacific 2nd Edition, page 1260. So you can read and review the case if you like. The open door of supervisory control, they say, is an appropriate action in interlocutory cases. Under the current leadership of McGrath, not so much. The U.S. Supreme Court has opened the door to mandamus issues, saying writ of mandamuses are appropriate, but their decision in 2009 specifically talks about privilege issues. If privileged information is disclosed, then a mandamus order can be sought to keep the privilege maintained. Even they use the language in that particular discussion. They say a bell cannot be unrung. Once the information is released, when the damage becomes irreparable to these interlocutory rulings, if a case is kept pending indefinitely, irreparable harm occurs. Something needs to be done. What? The avenues exist, but they don't always provide the remedy, especially if the court that the request for support is brought to doesn't care. Or they do care, they care about keeping everything status quo. There's one other way around it, and that's called a collateral order doctrine. But that only protects if the issue that's being affected is separate from the actual merits of the case, so it's even narrower than most of these other aspects. In practice, interlocutory appeals would literally and forever just bog down the courts into just such mire, nothing would ever get accomplished. Can you imagine if every single decision that a court justice made was appealed? It would be absolute chaos. I'm going to go ahead and grant your motion for discovery. Your Honor, I'm going to file an oral motion of appeal on that issue. Okay. We'll come back and convene when that appeal is overheard up to the appellate court. Appellate court rules on it. It comes back down maybe a couple months later. They go back in the same hearing. Okay, I'm going to once again grant that order because the Supreme Court upheld my decision. Your Honor, I'm going to appeal that appellate decision. Boom, right back up. It would just go on forever and ever and ever and ever. The ruling and the practice is sound. But once again, we go against what's called the spirit of the law versus the letter of the law. The spirit of the law is to allow interlocutory rulings to exist to keep a case moving and to hold and preserve assets and custody issues and every aspect of a case so that the harm that's being requested to be prevented or reimbursed for doesn't get worse. That's what an interlocutory ruling is for. That's why you have restraining orders. That's why you have custody or preliminary custody issues. You have, all these issues that are standard. That's what interlocutory rulings exist for. Not to settle claims, not to allow assets to be disposed of, not to allow any permanent harm to occur in the course of the proceeding, but to keep just the opposite, to keep this from happening. But if the justices are more interested in simply not hearing a case and will allow irreparable harm so it makes the case moot, so there's no longer a case to be heard because the damage, what's being requested is gone. What do you do then? That's when you have a conspiracy. And that's when it becomes part of a power structure that allows for these people to simply maintain their power. And as I've said before, remember, attorneys represent 1/3 of our government. Just flat out, you cannot hold a judiciary position in our government if you're not an attorney. And then those attorneys also take offices in the judiciary or in the legislature. They take and run for frequently. They run for governors. They take positions within the executive branch, and when they're not the actual heads of those branches, they are often the support of those branches. They are a cabal that exists within the heart of our government, and they have absolutely zero government oversight. And I'm sure you're thinking, wait a minute, you have the Office of Disciplinary Counsel or whatever passes for individual bar associations, censorship or punishment of their own members. It's a self-imposed issue, ladies and gentlemen. The government doesn't come in and say, okay, we'll give you a license to practice law. That's about it. After that, the supervision falls over to the Bar Association. The Bar Association is not a government agency. The Bar Association is an independent practice. The American Bar Association is not a federal government agency. The Montana Bar Association is not a Montana government agency. They are self-regulated, and yet they are running our government, and they are protecting and sheltering themselves. And so long as we have that problem, and so long as we have this interlocking need to protect each other from harm and consequence, interlocutory orders allow a shield against consequence. Supervisory control and other remedies only work if the Supreme Court justices are willing to call out the corruption in the state, if they're willing to call out the existence of the Great Montana Conspiracy. They are not, and they won't because they're part of it. Hate to end on that note, but what else can be said or done about it? As always, if you like what I'm doing, please help support us. The information should be in the text attached to this video. If it is not, by all means, visit the original podcast source, which is monspiracy.podbean.com, or preferably go to YouTube, look for the Great Montana Conspiracy Podcast, like and subscribe. Support us through that. You can send material and fiscal donations. Information will be in that there. You can also send us information. Always want information, always want other stories, other resources. Give me ideas. Oftentimes my podcast subjects are brought on by someone else who's brought me an issue, and I say, oh, that needs to be discussed on my podcast. What you have here is an opportunity to help affect change. And if you think my voice has power, please support us. I thank you for your time, and as always, please be safe, and whenever possible, please be free. Thank you. A quick little addendum here. I realize as I closed, I didn't exactly explain what I was saying. The Montana Bar Association is not an actual agency within the government. It's not funded. It's not set up by the Montana Code Annotated. It is what's called an integrated agency, which means that it's created at the direction and order of the Montana Supreme Court, but it doesn't actually answer to the people. It's not an elected position. The members appoint themselves. It's supported by the fees of the attorneys, not actually the taxes of the state. And therefore, it's something of an independent agency. Although it exists at the directive of the Montana Supreme Court, it does not actually exist as an agency of the court, nor of the people of the state of Montana. So I just want to clarify that point so there's no question. And once again, whenever possible, please be safe. And obviously, whenever possible, please be free. Thank you.